This is Bloomberg Law with June Grasso from Bloomberg Radio.
A judge struck down Georgia's abortion law, which effectively prohibited abortions beyond about 6 weeks of pregnancy. That's often before women realize they're pregnant. Judge Robert McBurney wrote, "It is not for a legislator, a judge, or a commander from The Handmaid's Tale to tell these women what to do with their bodies during this period when the fetus cannot survive." His ruling means the law in the state reverts to its prior status, allowing abortions until roughly 20 weeks into pregnancy, although the state attorney general intends to appeal to the state Supreme Court, which already struck down the law on different grounds. Joining me is Elizabeth Sepper, a professor at the University of Texas Law School and an expert in health law. Liz, will you tell us about the history of the litigation over this Georgia abortion ban?
So 2 years ago, the court here held a trial on the constitutionality of Georgia's 6-week abortion ban and entered an order largely enjoining the provisions of the law. But then the state appealed and the Supreme Court stayed the court's ruling to allow it to consider the full merit of the constitutional argument. And so with this reversal, it went back to the trial court, and now the trial court again has determined that the law violates the state constitutional protections for liberty, privacy, and equal protection.
Does Georgia law have a broader right to privacy than federal law?
The Georgia Constitution protects liberty in a due process clause that looks a lot like the U.S. Constitution, but was more recently ratified in 1982 and has been interpreted by Georgia courts to encompass a right to privacy.
I thought that the language was sort of stunning. Until that life can be sustained by the state and not solely by the woman compelled by the act to do the state's work, the balance of rights favors the woman. Can you explain his reasoning?
Sure. On the issue of the pregnant person's liberty, the Georgia Constitution protects a right to be let alone. And like many other state constitutions, this means that individuals get to make choices about their own bodies, including the right to refuse medical treatment or to take medical treatment that we might disagree with. And the court here says, look, there's a compelling interest on the part of the state in protecting fetal life, but there's a fundamental right on the other side of the ledger. And on balance, until viability, that balance favors the woman, so that abortion prior to viability has to be available to her, that otherwise the state is conscripting her into service to the state in a context where the fetus is entirely dependent on the pregnant person and the state can't assume responsibility for the fetal life.
Also, he said that the Georgia ban isn't narrowly tailored.
Right. He says it's not narrowly tailored because it is so broad, and that the state can't advance its interest in fetal life by so overwhelmingly destroying the pregnant person's ability to control her body and to make decisions about medical treatment, that only post-viability line can the state apply its law so broadly.
And tell us a little about the claim under the Georgia Constitution's Equal Protection Clause.
Right. So under the Georgia Constitution, the Equal Protection Clause requires strict scrutiny, so the highest level of constitutional review where you have an infringement on a fundamental right and the state is sorting people. So the plaintiffs here had made a number of arguments about the ways that the law was sorting people, and the court here in particular highlighted that the state, as some other states have done as well, has allowed pregnant people to access abortion for medical emergencies, but then has said that mental health crises are not accepted from the abortion ban. And the court said, look, right, healthcare crises that involve the brain, which is a very important organ for our functioning, can't be treated differently than crises involving the body, and that there seems to be some animus against mental health actually underlying this particular classification.
What do you think about the language of the opinion? He also referred to, it's not for a legislator, a judge, or a commander from The Handmaid's Tale to tell these women what to do with their bodies.
I think in some measure, it looks a lot like language that we're seeing from state court judges across the country. Now, sometimes that language is in dissent. I think here about the Iowa Supreme Court, which recently upheld that state 6-week ban over some pretty vigorous dissent, and in a context where that court had been stacked by Republicans so as to change the state constitutional protections. So here, what I think the trial court is doing is a couple things. He is telling the state Supreme Court that there is a long history here and that their position on the abortion ban defies the interpretation of the Georgia Constitution that courts had previously understood. I think the trial court also signals that he fully expects that the state Supreme Court will reverse him. He slams the Supreme Court very early on for its false modesty, right? It's basically its pretense that the court was sort of just calling balls and strikes and the Constitution means what it means, and courts don't actually play a role in telling people what it means. And he basically calls them out for engaging in nonsense on that point. So I think the major takeaway from this opinion is that abortion is not safe in Georgia. I think the voters of Georgia should be aware that it is highly unlikely that abortion will become legal in the state and the 6-week ban will remain enjoined. And so I think that's a really important point given the election year, where I actually think the timing of this decision is one that could really confuse voters, where they think maybe abortion is no longer an issue in the state.
And the next step is they'll appeal this to the Georgia Supreme Court?
Yeah, so the next step is an appeal on the constitutional issues. Again, I think highly unlikely that this decision stands for any period of time.
But I'm wondering whether doctors would even feel safe performing abortions in this interim period.
Yeah, so it sort of depends on the political economy of Georgia, I guess. You know, we've seen trial courts in the state of Texas, for example, in Kate Cox's case, right? Trial court had issued an order that would have allowed a doctor to go forward with an abortion for Kate Cox, and the attorney general threatened any hospital or physician that went forward that he would, in fact, prosecute them to the full extent of the law. We also saw in Amanda Zarofsky's case in Texas a win in the trial court that was immediately enjoined, right? So there was never sort of the time for providers to begin providing care. So that may well happen in Georgia as well.
I wanted to ask you about Louisiana. Louisiana became the first state to list abortion drugs as controlled substances. What does that mean for using abortion drugs in that state?
Yeah, so treating abortion drugs as controlled substances means that possession of mifepristone, misoprostol can be prosecuted as a drug crime. It's also affecting care in hospital settings because it's a controlled substance, right, requiring a lot more in the way of regulation and control over the drug. And these drugs are used both for non-therapeutic abortions, where people are seeking abortion, and also for miscarriage treatment.
If you look at how strict the state's abortion bans are, is Louisiana on the outer edge of most extreme?
Yes. I mean, it's a large and growing group of states that are on the outer edge of abortion regulation. I think it's important to put in context that Louisiana's criminal abortion pill law is consistent with the fact that Louisiana incarcerates people at a rate really not known in the developed world. So a very carceral state that prefers to deal with almost every kind of social problem that the legislature might identify as a criminal problem. So pregnant people are exempted from the law, but friends or family or anyone who possesses medication abortion just in case could be subject to the criminal sanction.
Besides Louisiana, do any other states' abortion laws stand out to you?
You know, there are a number of states that have very, very narrow exceptions. Tennessee is one with very narrow exceptions. There are states that require, for example, substantial impairment of a major bodily function be irreversible in order for a doctor to perform an abortion. I suspect that the legislative term beginning in January is going to come with a lot of innovations in abortion law. We'll probably see things like travel restrictions. We may see more states follow Louisiana's model in criminalizing abortion pills as controlled substances. So I think there's just a lot of lawmaking in this area and a lot of competition between states to regulate more thoroughly.
And on the opposite end of the spectrum from Louisiana is California. Tell us about its lawsuit against a Catholic hospital.
So California has filed a lawsuit under the Emergency Medical Treatment and Labor Act against a Catholic hospital that refused care to a pregnant person who was miscarrying. And this is really an important lawsuit because we know that hospitals, even before Dobbs, and in particular religiously affiliated hospitals, had been denying and delaying care for miscarriages to people and also for treatment of ectopic pregnancies. And so this is really an attempt to make sure that hospitals within jurisdictions that are committed to abortion care are providing abortion care in those sort of narrow situations that the federal law requires. So where someone's health is in serious jeopardy unless they get an abortion. And this is in line with the cases that we're seeing ongoing both in Texas and Idaho. Idaho's case had gone up to the Supreme Court last term, but the court basically punted, raising the question of what the federal law requires of hospitals and what they have to do under abortion bans. California's lawsuit doesn't involve an abortion ban, but does involve the question of what is the contours of EMTALA? What kind of protections can people who are pregnant expect when they go to an emergency room in blue states and red states alike?
There are a lot of states where abortion will be on the ballot. How much do you think abortion will play in the election?
I mean, abortion seems to be playing a role in motivating voters both to vote and to vote in favor of abortion rights. I think it's essential that we understand that abortion rights are at play at both the federal and the state levels. So even states that have ballot initiatives to protect abortion are, of course, subject to federal jurisdiction. And if we have a second Trump administration, the Trump campaign and Project 2025 have made very clear that a national abortion ban is a goal and that the Comstock Act could act as a national abortion ban. So I think it's important to think about the states, think about what protections they could put in place for abortion or impediments to abortion. But we live in a federal system, which means what happens at the federal level matters quite a lot for access to health care.
So much is at stake in this election. Thanks so much, Liz. That's Professor Elizabeth Sepper of the University of Texas Law School. Coming up next, lawsuits are piling up over election rules. This is Bloomberg. The lawsuits range from disputes over mail-in ballots and purging voter rolls to how to run the voting and finalize ballot counts. Republicans have filed a landslide of election lawsuits in more than half the states to challenge voting rules and election processes. But there's a clear concentration of lawsuits in swing states like Arizona, Georgia, Michigan, Nevada, and Pennsylvania, perhaps sowing more confusion before the election than anything else. Joining me to clear up the confusion is elections law expert Derek Muller, a professor at Notre Dame Law School. Derek, the Republicans have been filing lawsuits across the country. Is there anything different about these lawsuits than in other years, either in numbers or in the kind of lawsuits?
Yeah, I mean, I think the RNC's lawsuits earlier this year, there's sort of a tranche of them that they were filing at the beginning of 2024. I think the theme was we want to file these before the election so that we're not caught flat-footed after the election. There were obviously lots of disputes about changes to election rules in 2020 and some challenges that arose in states like Pennsylvania about how they were counting absentee ballots. And some of those rose too late in the game, right? It becomes just unrealistic to seek a remedy. There's not adequate time to evaluate the measures. So I think the RNC's efforts here, sometimes intervening in cases, sometimes trying to protect existing laws, and other times filing lawsuits to challenge laws, is to sort of set the stage ahead of the election so that, I mean, even if you lose, you had your day in court as opposed to the case being thrown out altogether. So there's no question we're seeing a high volume of cases being filed. But in some respects, it's less than 2020. I mean, in 2020, we had so many changes because of COVID, so many late-breaking changes by legislatures or by state executives, or people suing to say that the executive should have done something, the executive shouldn't have done something, whatever it might be. And so we definitely see a good chunk of cases this year, but in some respects, not nearly the volume we saw in 2020.
Do you go along with the theory I've heard espoused that these suits lay the groundwork for if Trump or Republicans lose the election, then these suits are the groundwork for more suits challenging the election results?
So I don't know how much it can lay the groundwork for more results. If you lose before the election, it seems hard to say that you're somehow going to file a lawsuit to win after the election. Or if you've filed a claim before the election and the court passes on it, I suppose there are certain circumstances where they might segregate the ballots, and then maybe you have a dispute to resolve after the election. So that happened in Pennsylvania in 2020, where there was a dispute out of the Pennsylvania Supreme Court about changing the receipt deadline for absentee ballots by 3 days. The Supreme Court issued an order sort of asking Pennsylvania to segregate those ballots and hold them off to the side. I mean, it was never resolved because there was really no dispute at the end of the day about who won the election. The ballots wouldn't make the difference. So maybe we'll see that in places, but I'm not sure. I think probably the more concerning thing is obviously that you sue, you file up lawsuits. Even if you lose, you sort of have this sort of dissension or dissatisfaction about some of the allegations in the complaint, and that people are worried at the end of the day about the legitimacy of the outcome, doubting its legitimacy. But I'm not sure how viable sort of pre-election lawsuits are going to be for post-election challenges. If you win, you shouldn't have a challenge to file. And if you lose, it's not clear the challenge would succeed after the election.
So let's go through some of the challenges in different states. You mentioned Pennsylvania. Republicans have been targeting mail-in ballots. Is it proven that Democrats vote more by mail-in ballots than Republicans?
Well, the conventional wisdom until about 4.5 years ago was Republicans used absentee ballots more than Democrats. You can see military personnel to the elderly who heavily relied on absentee ballots. That's why Florida had such extensive absentee ballots. There's evidence that minority populations are more distrustful of the postal service, and so they would prefer to vote in person. And then COVID sort of flipped all of that. Democrats thought that absentee ballots were the safe way of extending voting to everybody, and then Republicans insisted it was safe to vote in person, and somehow absentee ballots have become rife with fraud. So I think sometimes you've seen that inversion. It certainly played out in 2020. I certainly don't think it's as dramatic in 2024, if it exists at all. And I think there's still something in the water for Republicans who are told to vote in person and not vote absentee, or doubts about the absentee system. So that's probably suppressing turnout, Republicans suppressing their own turnout by refusing to lean into absentee ballots. But at the same time, Democratic requests are down too. I mean, we don't have as robust absentee ballots in some places as we might have seen during COVID, during the pandemic. So people are returning more to heading back to the polling place. And again, in some states, they clamp down a little bit on some of those absentee notices. You're not automatically eligible for absentees in Florida anymore. You have to request them every 2 years, things like that. So I think we're going to see it come closer to parity, but it does seem that Democrats are more inclined to use absentee ballots. It's just a question of how significant that disparity is in election cycles like this one.
So Republicans, according to the New York Times, have filed more than 20 lawsuits related to mail-in voting. And in Pennsylvania, they argued that voters should not be notified of any errors in their mail-in ballot, nor be allowed to fix them. Do you think that will succeed?
Right. So I think there are opportunities to cure ballots, and there are processes in each state to do so. But I think the key here is, in this lawsuit in Pennsylvania, is that you have all these different counties doing all different things. And in some counties, the county clerk gets your absentee ballot. It's missing a signature. It's missing the date. It has your spouse's signature instead of your signature on it, whatever it might be. And the county calls you up that same day and leaves a message on your cell phone and says, hey, just so you know, your ballot is defective. If you need to come cure it, come down to the county. We can do it. Other counties don't do that at all. There's a question of what state law requires. And in some respects, I think there's trade-offs to think about here. On the one hand, you can say, listen, that the absentee system shouldn't be this process of sort of bespoke get-out-the-vote efforts from county clerks. On the other hand, you could say, well, it's reasonable for county clerks to want to make sure that the paperwork is complete, just as any other paperwork you might file at the county where they're going to say, hey, you screwed something up, why don't you come fix it? But I think the key out of this is that we want consistency across the state. And I think Republicans are going to want to say, no, the law doesn't permit this. We need to have kind of strict compliance and no ability to notify. And Democrats are going to say, well, no, the counties should be able to notify, should notify these things. But, one of the more troubling things is to see this inconsistency playing out, where in some counties it's one way, in other counties it's another way. So I don't know how these lawsuits are going to play out at the statewide level. Part of this is a technical matter of what state law authorizes or doesn't authorize county clerks to do, where discretion lies, things like that. But we'll see as this one plays out whether or not some uniform guidance is given.
Is it an indication Republicans won a similar case where the Supreme Court ruled that the ballots that are missing dates on the outer envelopes couldn't be counted?
Yeah, so that Pennsylvania case, again, it really was a case thrown out on procedural grounds because the plaintiffs in that case they sued the Secretary of State, but also two counties, just two counties. And maybe not surprisingly, Democrats sued the most overwhelmingly two Democratic counties in the state to say you should count these ballots. And the Supreme Court, in a divided order, said, look, you really needed to bring all of the counties in here. I think it's laudable to think about wanting consistency, right? Either they should all count or they all shouldn't count, but there's going to be a consistent rule across the state. Now, here it is, the first week of October, and we're still engaged in litigation that we've known there have been problems about in Pennsylvania for 2, 4, 6 years. And again, we're at the 11th hour litigating these issues. But yeah, we're watching Republicans and Democrats fighting not just about the interpretation of the law, but how broadly it applies across a given state.
So let's go to Mississippi, a state that doesn't seem to be in question, but the Republican National Committee and the Mississippi Republican Party are challenging Mississippi's policy on late arriving mail-in ballots. Mm-hmm. This issue, I think, has been litigated before in other states. Is there particular significance to this case in Mississippi?
Right. So the focus here is to say that the federal election statute that sets the first Tuesday after the first Monday in November as Election Day requires all ballots to come in by that day. And you've seen occasional litigation, but in 2020 in particular, some of the litigation was about some of the late changes to the rules or ballots without a postmark and whether or not those that came in 3 days after the election could still be counted, because there's at least some ambiguity about whether or not they came in the deadline, whatever it might be. But here, by pressing it as a federal law issue, you're not dealing with state-specific guidelines. And suing in Mississippi, is trying to send a signal by suing in the Fifth Circuit, which is one of the more conservative courts of appeals in the country. And, that case is now on appeal in the Fifth Circuit in front of a pretty conservative panel to say, well, maybe if we can establish this precedent here, we can also establish this precedent nationwide. And this could affect hundreds of thousands of votes and maybe hundreds of thousands of votes in a state like California alone, in addition to other jurisdictions that might accept ballots after Election Day. So some challenges, I think, on the merits. States have long accepted ballots before Election Day and treated them as, well, we're just holding them and then they're actually cast on Election Day. Could you say the same thing is true for ballots that are just in the postal system for a couple of days before they land at the county? As long as they have an adequate postmark, things like that. But the effort here is to sue in the most sort of favorable jurisdiction and try to secure a win that maybe the Supreme Court has to take or that maybe can be carried across to other states. So we're waiting to see how the Fifth Circuit rules on that one.
The Fifth Circuit. You said one of the most. I always say the most conservative.
That's what it depends on your metrics, right? There are more Republican-appointed judges in the Eighth Circuit, but, the Fifth Circuit maybe has more panels that are likely to push the law into some of the most conservative directions, I suppose.
I agree with that. And coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Derek Muller of Notre Dame Law School. We'll talk about Republican efforts to purge the voter rolls in several states. The Republican National Committee says it's involved in more than 120 lawsuits in 26 states in an aggressive attempt to challenge voting rules and election processes before November 5th. I've been talking to elections law expert Derek Muller, a professor at Notre Dame Law School. So, Derek, one of the things we hear Republicans complain about over and over, particularly Donald Trump, is that ineligible people are voting, illegal immigrants are voting, dead people are voting twice. So in some states, they're suing to try to purge the voter rolls. I think Nevada is one of the states, right, where they're trying to purge the voter rolls.
There are issues all over the country. I mean, so part of it is, in theory, you're not supposed to engage in some of this routine list maintenance within 90 days of an election under federal law. But there's also some questions about, some of these issues might have been held up earlier and questions about eligibility. And there's no question. I mean, every state has ineligible voters on its voter rolls. That's just a fact of life. When you die, your name isn't immediately removed. It's usually removed pretty quickly, often within a month, but not immediately. If you move, there might not be evidence that you've moved for some time. So there's lots of questions that can arise for these voter rolls, and the states have list maintenance procedures pursuant to federal law that they're kind of obligated to undertake to try to make sure those voter rolls are as clean as possible. But at the same time, you can think sometimes these are a little bit overstated. In most states, if you fail to vote for an election or two, and there are other contingencies in there, they'll move you from active status to inactive status. And so inactive voters have to go through an additional sort of proof of residency requirement before they can move back to active status. So even though the voter rolls might be bloated in some places, you could say, well, there's a number of inactive voters here. Maybe they're ineligible, in which case they're not going to vote, and maybe they're eligible, in which case they can prove it and get their names, moved off of one list to the other. So you'll see occasional claims about hundreds of thousands of voters removed from the register in various states. And then no question that states have different levels of scrutiny that they give and different aggression that they have in terms of keeping those lists clean. But, at the end of the day, I think there are some occasional errors that can be made with these ballots, in particular in states that automatically mail absentee voters a ballot. There are concerns that if your voter rolls aren't clean and you're mailing everyone on the list a ballot, like in California, it's going to get to a non-trivial number of ineligible voters. But, on the flip side, in most states, if you don't have that, or if you have some good procedures, sometimes you're just fighting kind of cleanup issues. How accurate does it have to be on a given moment to keep people who are eligible on the list and take off the ineligible from the list? So we're seeing these sort of battles play out. It's Nevada, it's Arizona. There's all kinds of places where these things are happening. And it's a delicate balance to make sure that we're keeping the rolls clean for efficiency purposes and keeping eligible voters on there while not being so aggressive that, if you fail to show up to an election, we're somehow taking your name off the list or whatever it might be. So these are ongoing issues that have been happening for years in the federal courts.
So I'm wondering, it's in Arizona that America's First Legal Foundation is suing because they want the court to enforce a list of 24 orders that go with their interpretation of election law and correct any errors, et cetera, et cetera. I mean, it seems like it's a very fact-intensive kind of examination. Is that a trend in litigation or not?
Yeah, I mean, I think America First is being pretty aggressive on this. I think Judicial Watch, there are some other organizations you can find that have tried to get states to enforce their own voter registration procedures or list maintenance procedures over the years. And again, you can say, I think the state of Arizona is going to come back in a very fact-intensive way, as you indicated, June, to say, look, we are doing this. It might not be on the timeline you want. It might not be with the level of scrutiny that you're suggesting. You want us to look at, this kind of birth date and middle initial. We're looking at the full middle name, or whatever it might be. There are ways of sort of doing the verification checks. There's ways in which there's administrative deference given to say, we're going to purge maybe every quarter when somebody wants you to purge every month or whatever it might be. So these can be really specific minutia of, is there an administrative guide in the state that's validly promulgated by the Secretary of State about what you can and can't do in these circumstances? Are these things just left to the discretion of election officials under state law? Or if it's discretion, are these officials abusing their discretion by so flagrantly ignoring what the state law requires? So it's highly fact intensive. And, I'm not confident in any particular outcome in any of these cases, but it's really sort of picking at some of the edges of a lot of these issues for the most part in these jurisdictions. It's usually not sort of a wholesale ignoring of election law under state law. Again, secretaries of state have every incentive to try to keep the lists clean. It's a question more of some of the pragmatics and about what you think the most effective means are. To be frank, right, the plaintiffs in these cases have a different thought about what would be most effective. And if they were running the Secretary of State's office and had lost the last election in Arizona, for instance, they might have had different procedures in place. But these are some of the challenges that you have when something is typically left to the executive, and then you sort of have these lawsuits coming in over the top, insisting things should be done in a different way.
There was a lot of questioning of how the changes in election boards and different changes at that level would affect the counting, et cetera. And there's a lawsuit in Georgia challenging the state election board's decision to allow its members to conduct a reasonable inquiry into an election's results before certifying them. I'm not sure what a reasonable inquiry is and how that differs from what they have been doing.
Yeah, I mean, that's, I think, the real question. There's already state law that kind of authorizes this. The election board adds this language into the administrative code, but it's not formally out of state law. It's something you could probably infer from state law, but not formally in state law. Then it's not something that is specifically defined, even in the administrative code. So you can imagine situations where an election board, so the election's on Tuesday and the board has to certify by Monday. So that's 6 days. So whatever reasonable inquiry mean, it can't mean a whole lot. But you can imagine you have 18 precincts and you only get 17 sets of results. And you'd say, well, wait a minute, let's go find out where that 18th sheet is. I think that's a reasonable inquiry. One of the precincts reports 0 votes cast. Well, let's go figure out what happened. Or one precinct indicates 1 million votes cast. We probably want to look into that too. So there's ways in which you could imagine quite benign and I think quite reasonable ways in which the board, before it feels like it can certify a result, wants to make sure it has all the paperwork in front of it. The real challenge is you have this undefined term, you've injected it into the administrative code. Is this going to give some pretext or some cover to election officials who are saying, no, now I get to go, ask for the inside of the voting machines, or now I want to manually tabulate this batch from this precinct because I'm skeptical or whatever it might be. So I think the question is spinning out forward how a phrase like this could be used or misused by election officials going forward. So it's in one sense, it's kind of benign on its face. In other sense, it's like, well, it could be used as a pretext. And I think that's what people are concerned about, how it might be used in unknown future situations.
Yeah, because I think a fear is that, especially in these close states, in these battleground states that really count, that there'll be some kind of refusal to certify, or the boards of elections will mishandle the vote. I mean, there's a lot of concern that at the state level, there won't be a fair count.
Yeah, I mean, I think if you have the tabulations from the precincts that are given to the county, and anytime that a county board or any entity is going to change or alter the votes, I mean, you have the before and after numbers. 4 years ago, I was in Iowa, and there was a congressional district race that was very close, and twice precincts in an election that was decided ultimately by 6 votes, precincts found mistakes they made in their results as they were going through the canvass. And so they had their first results, the unofficial ones, and then they had to update them with official ones that flipped hundreds of votes. So you have that record, right? You have the sort of before and after, and you have the explanation. So if an election board does something, it gets the results and says, we're not going to certify. Well, that's easy. We have the vote total. Or it says, the vote margin here is Trump by 1,000, but we're going to say it was Trump by 8,000. So again, just making up numbers. You have before and after results. So there's typically going to be an easy process if somebody disputes that to go into court and say, they didn't certify, can you order them to certify? Or if they won't certify, court, can you do it for them? They certified this new total where they fiddled with the results. Can you go back to the old total because they had no basis in doing so? So I think there's no question that there's concern about meddling in the election process, about altering totals, about dragging your feet or trying to deny or subvert the winner. And that has major political consequences, public perception consequences. I think those are bad things. But I think there's also a strand to think about what's the legal effect of this at the end of the day. It might delay some certification by a day or two, maybe in some places, but to the extent that the courts step in and say, you really have no basis whatsoever to do this, I think you're going to see courts move in swiftly, as they have done the last 4 years when election boards have tried this in the past. Obviously, a lot more pressure in a presidential election, but we'll see how it plays out.
You're more hopeful than I am.
Well, I think, again, we can anticipate all of the worst case disaster scenarios, there's no question, and think about what those things are supposed to do. But, we still have a lot of courts that step in, and they, you can file as many lawsuits as you want in 2020. It's not going to change the results of the election. You could talk about Georgia, where she was on the other foot for Democrats in 2018, and really there's not going to be a change in the results despite filing lawsuits, whatever it might be. So, at the end of the day, the system's pretty resilient. Now, again, there's major political questions. There's major public perception questions about democratic legitimacy. And it's not good to have a public that doubts the outcome of the election, or that you have public officials sowing distrust baselessly because it's a way of fundraising. It's a way of whipping up frenzy. Those are not good things. But there's a piece to say, listen, at the end of the day, the winner is going to take office and the loser is going to go home. And that's the way the system is supposed to operate. So I'm optimistic on a legal side. I might be less optimistic on the political and public perception side, but there's only so much we can do to control those things.
Thank you so much, Derek, for your explanations of these often confusing election law issues. That's Professor Derek Muller of Notre Dame Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.